say, oh, that's not important, let's not look there. And somewhat the interests of deciders can be like that too. They can say things like, you know, for the most part, these decisions that are being made are perfectly fine for me. I don't want to spend the resources or the money to debug or figure this out. I'm getting sufficient return on my investment, I'm happy. Or decision makers might even want to go a little step further. Back to that example I said about how there's an ugly tradition of not wanting to employ women who might have babies. They might want to find other ways to discriminate against those people without admitting that that's what it is. And they just hide it in the software system and then don't say that's why. You know, so the interests of deciders and developers are different than those of those being decided about. If a decision-making system that like rates your performance on the job or decides whether you get a loan is wrong, horribly wrong about you, you care. And you want someone else to care and listen. So individuals care about rare cases. Developers and deciders oftentimes do not. Okay. How am I doing on time? I know we started a little late. I think we've been at this about a half an hour. We're able to go till 11 if we want to. Is that true? Yes, okay. So now I'm going to give some specific examples of software systems that I would like to secure. Decision-making systems, socio-technical systems. So you're with me that we're not just securing a computer box, a computer system. We're securing the combination of human decision makers and the software system that are trying to work together. Are you with me? Okay, so I want to talk a little bit about the criminal justice system. And I was very happy to hear Tabisa Gandhi's presentation yesterday about the criminal justice system here in South Africa. That was really interesting. And I think you were showing examples of the way automating the handling, software systems to handle the dockets of electronic records and things like that could lead to better decisions. And I think that's very true. I think there's also a point at which over-reliance on software could lead you down a bad road. Okay? So I think what you said is absolutely true when you go from not automated or not software systems at all to software systems. But once you put a system in place, you have to, there are other mistakes that can start to happen. And I want to talk a little bit about that. In the US at least, there is a heavy use of software throughout the system for decisions of like how to deploy police resources. I don't know if you followed any of the discussion of predictive policing algorithms, but let me give you a quick summary of that. I predict there will be crime someplace, there will be more crime someplace, so I send more police to that area. Now wait a minute, if I send more police to that area, will they find more crime there? Yes, because they're there. So here's a place that might have also crime. I didn't send police there. I won't detect crime there because I didn't send them there, right? So it's almost like this self-validating system. I predict there will be crime, more crime. I send people and they find more crime. How brilliant am I? Wait a minute. You might have to keep in mind the fact that because you send people, they may find more, right? There's software systems used throughout the US to predict someone's chances of committing another crime. Okay. Now, this starts to sound like digital destiny, right? They haven't committed another crime yet. You're going to say whether you think they will commit another crime, and then, software that analyzes forensic evidence, so things that take DNA found at crime scenes, and then like takes DNA sample from a suspect and says, are they a match or not? These are all things that are being done with software. And if I think about this socio-technical system, there's software involved, there's also people involved. There's police, there's judges, there's defense attorneys, there's all sorts of people involved. And I think about the incentives, there's people who develop the software, and I think about the incentives in the socio-technical system and securing them. What do I think I'm securing? So here are some things I might think are properties I want to ensure, or I want to secure. I might say that I want to secure the right to a public trial. In other words, that the evidence against someone is not hidden away. The evidence has to be made public. Let me just give you an example. If I have a software system that can predict a number between 1 and 10, how likely am I to commit another crime? And that software says 10, you are really likely to commit another crime. And the judge says, oh, you're really likely to commit another crime, you're going to jail. Is that really a public trial? Just the fact that that machine said 10? What would it need to do to make it a public trial? You'd have to ask that system, why did you say 10? Am I right? Okay, so we'll come back to that. What about the rights of defendants to review and confront the evidence against them? You can kind of think about that also as part of the public trial. Or what about right to equal justice under the law? What if a software system treats one person more harshly than another person? Could that be a problem? Yes. Okay. So as I said, the criminal justice system in the US today makes heavy use of software and algorithmic decision making throughout the system. It is often black box proprietary software where defendants, defense attorneys are not really able to request explanations. And many times the rights of those companies and developers, their intellectual property rights, their right to not explain their stuff is deemed more important than the rights of defendants. And there's a large overconfidence in software results. Oh, the software said so. It must be true. And insufficient oversight and big hurdles to adversarial testing and review. So again, if I'm somebody whose business is to make software, and I'm making a good money, I'm making a good business, selling to the government software that says 1 to 10, you're likely to commit another crime or not. Do you think I want to poke holes in my software and show all the problems? No, I want to hide those problems. So who is it that's going to get in there and like fight against it and show, like, okay, maybe you're right here, but you're not right there, and you're not right there, and you're not right there. Who will do that? Yes? So I'm going to tell you some stories from the US. I already mentioned the idea of the Compass software that's used to assign a numeric score to a person's likelihood of committing another crime. There was a court case in the state of Wisconsin. A defendant, Loomis, and his defense team said, we want to be able to understand the number produced by the Compass software. We think we should have that right. And Wisconsin said, no, you don't have that right. And the Supreme Court in the US has considered picking up that case for review, but they have not. So that's currently the law of the land in Wisconsin, maybe unclear in other states. I think that that's the wrong ruling. But I'm going to talk about the case of the forensic statistical tool, FST, that was developed by the Office of the Chief Medical Examiner in New York City. And it's a piece of software that matches evidence found at crime scenes to a potential suspect. It is matching whether the DNA found at the crime scene matches the suspect's DNA. And interestingly, if you have a DNA sample that's a very clean, crisp sample from one person, and you want to compare it against a suspect, that is really hard science, good science. You can even visually look at the electropherograms and be like, it's a match. But if you have real crime scene stuff, like say this bottle was found at the crime scene, how many people have touched that bottle? I don't know. 5, 6, 7, who knows? And now it's all mixed together. they say, oh, it's too hard for people to determine that anymore. The software will tell you. But there's a lot of iffy stuff happening down in there that defendants or defense attorneys might want to really delve into the details and question. Okay? So here's an example of what's happening in our decision-making landscape that we need to secure. It's an example of problems. In this case, in New York City, this software was put online in April 2011. So it's like, okay, we can use this for casework. And within weeks, they had to take it down because it wasn't acting right. You'd think that would be enough warning sign to be concerned, but no. They weren't able to put it back online until June 2011, and then they're like, it's fine, nothing to worry about here, perfectly good. Defense attorneys are like, we really would like to understand these numbers that you're just, spitting out and telling our clients did it. And judges are like, ooh, software, I'm sure it's right, okay? And there are bodies that are supposed to validate that you're allowed to use this software, but they didn't really do their job well. First of all, the developers are like, we went through that approval process. Okay, yeah, we tried to put it online, and then had a problem went back online. We don't have to go back to them again. We didn't change anything that matters. And that body did not make them go back. Okay? And then, maybe I'll skip ahead a little bit. Basically, that software was used from 2011 to 2017. That's 6 years. And it was used, for 1,300 very serious cases, murders, rapes, just horrible things, okay? And there was no admission that there was problems. There was no description of changes. And when defense attorneys would say to judges, we would like an the strongest evidence you have against my client is this number put out by this software. We would like an explanation of how they got that number. We're not sure. We don't think our client did it. We have this other evidence. We don't think that could possibly be right. Judges would say, no, you don't have the right to understand that. That's their intellectual property. And people went to jail. And they aggressively resisted expert witness review. Defense attorneys would say, fine, you don't want to explain it in public. So, right to a public trial. You don't want to explain it in public, how about you just let our experts go in and look at it under protective order? They're not going to be able to say in public, they're only going to be able to say to the judge what they found. You know what the court said? No, you don't even get to do that. For 6 years. Finally, there was a judge who said, yes, that seems reasonable, you can do that. Huge win, right? The expert witness went in, and it's a hard job. There's like thousands and thousands and thousands of lines of source code. Where do you start to look for a problem? But, the person that they got was somebody who'd been watching this very carefully. And the OCME had produced this, when they first validated, they produced a bunch of examples of how it worked, of working on specific cases. And he reran it on some of those cases, and he found that it wasn't matching their published results. And he's like, I wonder why. And he dug into why. And when he dug into why, this is not displaying very well, which is why I wasn't kind of washed out a little bit. There was basically a 70-line function that they had added into the code to get over the bugs that were making it crash, so that they could put it back online. And you know what it did? It just dropped problematic evidence. It's like, it wasn't deliberately mean. It wasn't like we want to be mean to defendants. It was just like that aspect of the evidence makes our software crash. So you know what we're doing? We'll just ignore it. And sometimes the evidence that they ignored could help defense and sometimes prosecution. So inclusionary means you're more likely to say this includes the suspect. It's more likely they did it. and exclusionary means it's more likely to say it didn't, it was possible that this routine would drop both helpful, but both inclusionary and exclusionary evidence. So it's not like it was targeting hurting the defense. But what about rare cases? What about my case? If my case dropped a bunch of exclusionary evidence, in other words, you threw away the evidence that I didn't do it, I would like to know that, please. And these developers said, you know, it just would be really inconvenient for us to have to admit that we made a mistake in public. We don't, you know, it's just too messy to tell you that. We're going to just do that. And when the judge got this report back from the expert witness that was supposed to be kept secret under protective order, the judge said, no, we're going to publish this. Because it's just too important for people to know. So yay, it was a woman actually, yay her. And in fact, it went a little farther. The ProPublica, I don't know if you follow the work of ProPublica in the US. If not, I highly recommend you look up the work of ProPublica. You could start with their machine bias series. If you Google ProPublica machine bias, amazing work. I think you would find it very relevant to this talk and also maybe to your lives. So ProPublica and the Yale Media Freedom and Information Access Clinic said to the same judge, we would like the source code for that application to be released publicly. This was the thing they had jealously guarded, wouldn't let anyone look at. No, 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 not at all, not even under protective order. And she did. And that source code was posted on GitHub. That's a huge win for accountability and transparency, right? But you know what they did very soon after that? They switched to another piece of software, StarMix, produced by a company in New Zealand. In other words, you try to make them give up their source code, I bet you're not. See, this was developed by a government agency, OCME in New York. So if a federal, if a judge in New York says you have to give up the source code, they're like, okay, we have to. The company in New Zealand is going to be like, try it. It's like whack-a-mole, right? They found mischief in one box, and they're like, we'll just switch to another one. That's why we need more systematic enforcement of accountability and explanation. So one piece of work that I did that I'm really proud of, and like I said, my background is not in this particularly. I do big distributed system building. I do VMs and virtualization and cloud computing and security. But this was an example of where I just felt like it was too important. It's like, I don't care if this is me or not, it has to be done, so we're going to do it. The code that they posted on GitHub, you know what happened with it? Nobody did anything with it. And we're like, that cannot be. So we took the code posted on GitHub and we looked at that 70-line function that was added to and we just said, really what was the impact of that? I can show you an example where they're through some inclusionary and some inclusionary, but across the board, what did it do? And this is a paper that we wrote, The Right to Confront Your Accusers, Opening the Black Box of Forensic DNA Software. And I love that title because should defendants have a right to confront their accusers? Should they have a right to understand the evidence against them? I think yes. So we looked at that on OCME's own validation study. In other words, we didn't even give them a test they didn't know. We ran it on their own test cases. And we found that 23.7% of the samples triggered that evidence-dropping behavior. In other words, this wasn't even really a rare case. A quarter of the time, they were throwing stuff away. Now, it's not always that every single time what they threw away fundamentally changed the answer, but the fact that a quarter of the time they were throwing something away without telling anyone, just because it was inconvenient for them to do so, not okay. And not surprisingly, we found that when you throw stuff away that's inconvenient, you get less accurate. So, if you throw stuff away, you're more likely to falsely include people who are not guilty, and you're more likely to falsely exclude people who are guilty.